Hey, what's up, my YouTube fam? This is Larry, Invest and Build Your Credit and Wealth. Hey, today we're going to have an exciting video. We're going to be talking about how do you put together dispute letters for medical debt or collection agencies to try to get them to get this removed, to let them know, hey, I'm educated on what you're trying to do. And please remove this before I can take steps to the next level, or whatever you want to do to try to get them to negotiate with you better. Remove it off your credit report, anything. So these letters are really strong. I'm going to talk about my affidavit. So today you get nuggets today. So I'm going to tell you what I put in my affidavits, why I put them in, and why it's important to do these things. The next thing I want to say is, hey, thank you for all my new subscribers coming to the channel. I appreciate y'all. Continue want to grow this channel. Continually want to give out good information on what you need to do to try to get items removed off your credit report, or make a platform so even if you need to negotiate, that you can get this stuff off your credit report for little to nothing. And that's the main thing that you want and I want to do to try to help you reach. So you know the deal. Please subscribe, share, like, hit the thumbs up. You know, definitely want to continue to grow this channel and share this good, real credit information. You know the deal. I'm just not out here sending y'all a bunch of stuff that somebody else that said, that somebody else that said, that somebody else that said, and they keep passing because people just believe because it sound good. You got to remember, these credit bureaus been around for a long time. You got to understand what you're dealing with. And if you come off like you have no clue, they just on the other end laughing at you. So, you know, the main thing is I want to give you that powerful information to help you achieve your goals. So thank y'all for all y'all new subscribers. We're going to talk about these affidavits, and we're going to talk about why. The first thing I tell people, the reason you need to send out validation letters, never ignore them, is because you may get letters that are already indicated or have violations in those letters, because maybe they didn't have certain information in the letter that is required by the Fair Debt Collection Practice Act. So there's a lot of information that is required, and when they don't, you already have a hand up. So even if you say, you know what, these dudes are already violating the Fair Debt Collection Practice Act, this information that they were supposed to send me that is required in this letter, it's not in this letter. And you may want to just take them to court and win your case. So, you know, all of that stuff is important. And that's the first reason why you need to be sending in these letters, right? Is because I see letters all the time that there are violations within those letters. And there's certain things that are required in the Fair Debt Collection Practice Act that must be in a debt collection letter. So that's the first reason. So the first thing we want to talk about is medical debt. And I'm going to go over why I use affidavits. I use affidavits because I've learned over time, just sending in a simple letter, just saying, hey, I want you to validate this letter, doesn't really put the collection agency on notice that you really are educated and you really understand what you need to have. And when they exclude information that you know, well, maybe you don't have enough information to actually be collecting this debt, and you're holding pertinent information that if I see, that would let me know that you're not have a legal right to collect this debt. So we're going to go over a medical debt affidavit. And this is, I'm going to read over the things that I put. So these are nuggets. So and this information is in my master dispute package. I'm always updating. So now if you bought a package and I've updated something, I have no problem sending you updated information. And all y'all people, I know who buy the packages because I have their invoices and their names and all that other type of stuff. So if these are letters that you want, either or, you want that master dispute package, you know, the deal, shoot me an email and we'll discuss it. I have no problem talking. If you want to talk to me before you purchase, no problem, because I believe in what I'm passing out and what that I'm even selling to consumers, to y'all. I'm a big believer that it's effective And no, they're not just a whole bunch of template letters. I don't believe in that. I believe to give you the information to produce the letters, because everybody's credit situation is a little different. And if I just put a letter out there, I mean, there's some letters in there, but they're really a guide. They're not letters for you to just use over and over again. You need to understand what you're doing and understand the law. So when you put the letter together and you're sending it out, those creditors know that you're educated about what you're doing, and they're going to make sure that they are following the laws, regulations, and policies that are required. So the first one we're going to go over is the affidavit, and I have to read it here, so I'm going to read it over to you because I know I can't remember all this stuff offhand. So the first one we're going to talk about is the affidavits for medical debt. So I always put at the very beginning, I always put the affidavit is a statement of facts. I'm sending you an affidavit because I want the statement of facts. The reason I do this because at some point you may just be upset, mad, and believe that these people do not have a right to this money. You want to make sure you're sending out this stuff. So if you want to consult an attorney, a lawyer, take these people to court, you're putting together something that is viable that you can use to say, I asked for this particular information. This is what I sent them. So I understand what is required of them now, because they didn't understand in this court of law that now we're on a different playing field, and a lot more things are required by them to show that they have legal right to collect this debt. But I wanted to show the court that when I was asking questions, because I need to know, do they have a legal right to collect this debt from me? There are so many people out there scamming people for debt, trying to collect debt that's reached this statutory limitation, threatening you, calling you, talking about they about to send a summons to your door, all kind of crazy stuff. So I'm doing this to protect me, to make sure that I have a legal obligation to pay these people. So let's start off. So the first thing I do, I always put come now, and I put the company name and undersigned affidavit sworn on oath, and state the following. I put that he or she is an officer of the collection company name, that as an officer/agent of the collection company name, he or she has the authority to execute this affidavit on behalf of the collection company name, and is bind the company and individual to its provisions. Then I say the collection company understand all the laws regarding the Fair Debt Collection Act in accordance with 15 USC 1692G, the Fair Billing Act, your State Debt Collection Practice Act, the Fair Credit Reporting Act, Section 623, which is in Section 1681S, also the Section 617, which is 1681O, Section 605, 605A, 1681C, and the HIPAA privacy rules, which is the Health Insurance Probability and Accountability Act, Section 45 CFR Part 160, 162, and 164, and the Medical Model Debt Protection Act. So then I want them to know, hey, all these things, there are sections in each one of these sections that are required by you to make sure you follow in trying to collect on this medical debt, right? Then I always put, if a debt collector for a healthcare provider violates the laws, the patient would have a private right of action under the State Unfair and Deceptive Act and Practices, which is the UDAP law, and associated with damages or injunctive relief. Then I go down and say the collection company Now I'm asking questions now. Can the collection company name, can I be sued for this collection account? Right? Has this account reached its statutory limitations to force collections in the state that you are in? So you should look up your state and find out what is the statutory limitations for them to force collection on you. Every state is different. The state of Texas is 4 years. I just moved from California, 4 years. You need to find out in your state the collection company name, because this is when I go back and say they can't even force collection. They're trying to collect on a debt. They can't even force collection. So, and you can change this. You could take this out if it doesn't apply to you, right? So you can say you can force, because you can't force collection on this debt, I have no obligations to pay you. And because of this, you are using my credit report to force collection of this debt. Now, because they can't force, for y'all, people need to understand that is leveraging power to help try to, some people don't want to deal with court. So, but you want to settle and get it off. This helps your leverage to try to settle the debt for less, because they're trying to get something, because they could literally waste their time and money. You have to realize they have employees that they have to pay, right? So understand this. You have a leverage, because if they can't force collection on you, and everybody said, man, I'm just going to ride it out. All those times and hours they're trying to collect on debt, they won't be able to pay employees the money they want to pay, because they're not going to be bringing in that money. Then they would have to sue more people, have more documentation to even get that money. And that's not what they want to do, especially for a $500 debt, a $700 debt. They don't want to do that, right? You got to know your leveraging power, right? So you got to understand, by doing that, and they can't force collection. Hey, you can't even force collection on me. I don't have to pay you, right? So we need to come to some better negotiation to even get this removed. And I have strategies for that. That's why I use that restrictive endorsement letter. But I have videos on that. So then after that, I go into the collection can understand that this verification says validation of the alleged debt is by affidavit. Sworn statements as per the Fair Debt Collection Practice Act, and this affidavit must be notarized to become a valid verification. Then I go to my next statement. The collection company name understands that the original creditor has given the collection company name, whoever it is, full billing statement and the date of service. In addition, naming the client's name, which would be your name, as the patient receiving service that includes address and has verified service has not been paid by the servicing medical insurance provider. A creation of a medical bill, meaning they changed the amount. That's why you always want to know what that original, because they may send you something different than what the original creditor said. So listen to this. The creation of a medical bill, and that's what it would be. If it doesn't match the original bill and you get a whole nother bill, right, with a different amount, check this out. The creation of a medical bill is a HIPAA violation and carries a fine as much as $59,522. Charging interest on a medical bill that is not part of the original agreement for billing is a violation. So if you get a medical bill on the original thing and they just, because collection company, you know the deal, they do all that stuff that when you're not educated, and then all of a sudden they're applying interest on a medical bill. They can't do that if it's not a part of the original agreement, right? That's why that's in there. The next step, the collection company understand it is prohibited to send medical debt to collection under 180 days after the patient is sent the initial bill, right? And it's required the medical aid to provide an itemized statement to patients for medical or hospital debt and to notify them of their possible eligibility for charity care. That's why you may not even make enough money and be under the, I did a video on this, under the poverty level, and there may be assistance for you to pay that debt. You got to know this stuff, right? Then I go on to say the collection company name understands that your name, you just saying your name, is requesting a copy or copies of the complete billing information that clearly gives billing explanation of debt. Without providing key information about this debt, your name, I am forced to seek guidance in this matter. Then we go on to the next statement. The collection company understands that they are a debt buyer, and in your name, and requesting a purchase agreement to validate your ownership of this debt and your right to collect this debt. Remember, you could be a collection agency could be assigned a debt, and when they're assigned, there's an assignment agreement between the original creditor and the collection agency. And that's just an agreement that we're agreeing to try to collect this debt. Then you have debt buyers. They buy debt. No matter if it's a medical debt, they buy that debt. And there is a purchase agreement between the original creditor and the debt buyer. In that purchase agreement breaks down everything about that debt, what they paid that debt, how much they paid for that debt, all that information. That's why they don't want to send y'all that, because that's why they just want to send a photocopy of a bill, because they don't want you to know what they purchased that debt for, how much. I've seen purchase agreements and they've highlighted it out, right? But they're still trying to collect the full amount, but they dirty. They dirty. But they don't want to send you that information. Check that out. They don't want to send it. But I'm going to put that in there, and they don't have to send it. But I'm going to put that in there so they understand that I know that you purchased this debt. And if I feel like that I don't agree and I'm going to fight it, I know what you're supposed to have. And I know when I look at an attorney, I know that I'll be better working with this attorney to try to get out of this debt. So that's why I put that in there. And then I also go down and say, the collection can understand that sending unsubstantial demand for payment through the U.S. mail system might constitute mail fraud under federal and state laws. It is understood that reselling, reassigning, or sending unverified debt to another debt collection is fraud. They cannot pass debt on. That's why you have to understand on a debt collection, and this is where people don't get it. If your debt has been passed on from debt collection to debt collector to debt collector to debt collector, that is what they call chain of custody. That information has to follow each one of those, because the original collection company, these are nuggets, they purchased that debt, or they most likely purchased that debt. So whatever documents they have, all that stuff must move. Just like in a court case, right? Chain of custody is everything. How that information moved from one place, from the scene to the police station, all that stuff. When there's a break in a chain of custody, that may be an issue. And it will be an issue. So that's why I put that in there, because there still has to be a chain of custody of that information that moves. And if you can find that there's a break in that chain of custody and information wasn't passed on, you're probably gonna get out that debt. So the next thing I put in there is understand that failure to respond by verified sworn statement to the point within 30 days to satisfy this request, the Fair Debt Collection Practice Act will be constituted as my absolute waiver of any and all claims against this alleged debt, and my tax agreement to compensate debt for costs and legal fees under the penalty of perjury, right? So if they don't follow the Fair Debt Collection Practice Act and don't send you information, that could be your way to get out of this debt. I also put in there, it is understood that verification is defined in Black Law Dictionary, the 6th edition, as follows: confirmation of correctness, truth, or authenticity. You know I'm tongue-tied, so don't be tripping on me. By the affidavit, oath, or disposition. The affidavit of truth of matter states an object of verification is to assure good faith of statement of the parties. So, and then I put sign. This first page is only for the debt collector. And then I have the second page, and it's simple. It just goes back over the affidavit, the collection company name. I say this is a response from the inquiry of the debt reporting. The collection, your name. I need to verify the accuracy of this debt. This is an attempt to receive the billing information to verify debt. I've never received any opportunity to validate this debt. Has this debt been validated? I understand my rights as a consumer and your obligation as a debt buyer / collection company. I understand HIPAA and my rights under HIPAA, along with the following Fair Debt Collection Act in accordance. And then I go back into all those regulations. And then I say this unverified debt must remove from my credit report under the Fair Debt Collection Practice Act and the Fair Credit Reporting Act. If not, I have a right to seek guidance with an attorney. And then I put, please, all correspondence must be through mail, not phone call. It is an attempt to collect the HIPAA form and information to validate this debt. And then go into your name and address. And then it says, I have attached an affidavit, which is the first page, to request documents to properly validate the debt from the collection agency name. By law, you must reply to this affidavit. I have notarized this letter and sent certified mail. You can do with delivery receipt, but all you need to do is send with certified mail. I am keeping record of all communication between I and the debt collection agent. You're going to print and sign the second page. So that is my affidavit I send out with my clients and people who have bought that package. That's what I put in there. So if they want to validate this debt, and this is why I do it that way. And this is why I use that form of validation when I'm sending in to a medical debt, right? And reason I put all those different regulations in there, because I'll let know I've looked at every single one of those, and I know if you're not following and you're not checking and you just out there just going to try to collect a debt, you better make sure that you're doing everything in the right fashion. Because if you're not, I understand my rights as a consumer. That's what it's all about. Doesn't always mean it's going to come off. It means that you're putting them on notice that you understand. Now, what you do with that from that point on, I'm all about leverage. Sometimes some things work, sometimes they don't. But when you create that leverage, you better have better negotiating tools, right? The next one is like if you're going to have a credit card or, a loan or something like that. Usually for credit cards, maybe a loan, I do. I am also, because I've been really working more on repossessions, I am creating an affidavit for repossessions because it's a little different. I did a video on it, but I'm also working on how to establish a great affidavit. And I'm trying to put certain things in there because every state has different laws. So I'm working on that. That's the next affidavit that I'm working on for repossessions. So it starts off pretty much the same, but it doesn't have HIPAA in there because this is not a medical debt. I just go in and say, I understand the verification of ownership of the alleged debt is by affidavit, sworn to statement per the Fair Debt Collection Practice Act and FTC, that this affidavit must be notarized to become a valid verification. Where it gets a little different, collection counsel understand they have firsthand knowledge of the alleged debt in question. The collection company, they understand they own 100% of this debt by way of a purchase agreement from the original creditor, or have assigned this debt with an assignment contract. Right? Then go to the next line that we go over is this one. The collection company has been given a purchase agreement to validate that they are the owner of this debt and legally have a right to collect on this debt. Studies show the collection agency practice requesting payments on debt they have no legal right to collect. This is why they limit the amount of information they send consumers about debt they claim a consumer owes. That's one of the main things I put in there, because a lot of times collection agencies, and there's plenty of cases out there where collection agencies are suing people for debt and don't even have a legal right to sue them, or have violated the Fair Debt Collection Practice Act. So it's so many different things. So I put that in there to let them know that studies show this is a normal practice of what they do, what collection agencies, companies do. The next line I go to is say the collection company, they understands it is the holder in due course and willing to accept all liability in the statement contained in this affidavit. The collection company understands this debt has not been sold to any other debt collection company without establishing ownership or validation of debt by transferring of the purchase agreement. Remember, if it moves from collection aid to collection, it's the chain of custody. It must be moving with it. The collection company name has verified the statute of limitations of this debt. In addition, if the statute of limitations have reached, you cannot force collection of this debt. If it's reached this point, you can't force collection. The other thing, the next statement said the collection company understand that a photocopy is not acceptable, and that the Fair Trade Commission has stated that a photocopy or a general ledger is not evidence of debt. They do it all the time. And then, like portfolio recovery, some of these people, you even send them a validation. They get to a point, they don't even send you that no more, right? They just trying to trick you into paying, right? So they don't send that because they know they don't even, half the time they ain't even got the legal right to collect it. They're going to trick you and put it on your credit report and try to force you. And not enough of us put pressure back on them to get that information. But they don't even do that. But they can't, a photocopy of a bill is not, in the court of law, they'll never win a court case like that. They better have way more information than that. They can't show up with a copy of a digital bill and say, you owe this debt. It don't work that way. It doesn't work that way. And so many people just don't know that. And that's why I'm trying to get this information out to y'all. A collection company, and the next I say a collection company, their name, understand that sending substantial demand for payment through the U.S. postal system might constitute mail fraud, just like any other one. It goes on to understand that failure to respond within 30 days will violate the Fair Debt Collection Practice, just like the other one. It is understood that verification is defined in Black Law Dictionary 6 editors as follow. Confirmation of correctness, truth, authenticity by affidavit, oath of the disposition, The affidavit of truth and matters stated and objective of verification is to assure good faith and the statements of parties. So, I mean, all that's in there. And then pretty much the statement on the second page is pretty much the same, but it's a little different. It says requesting the purchase agreement to include the signed agreement and all monthly billing statements to establish ownership and validation of debt. Your name is requesting a purchase agreement that was received from the original creditor when this debt was purchased. This will prove your ownership of the debt and validation. And then it say, your name is requesting all account ledger, all business records associated with this account, including all monthly statements to show accuracy of debt, since this will explain the debt in question. Failure to produce these documents show a clear indication of your knowledge of this account and how it was maintained. Can you prove the amount you are trying to collect is accurate? The next statement says, have the collection company verify the statute of limitation of this debt. If the statute of limitations has ran out, you cannot force collection on this debt. If the collection company name, which when I say collect, that's the name, verify the statute of limitations debt. No, I'm about to read the same line over again. If the collection company name is reporting this debt on my credit report without proper ownership or accurate documentation of the debt to force your client's name to pay this debt, could be subject to damages. A copy of a bill will not and does not give you the right to collect on this debt in a court of law. This has been stated by the Fair Trade Commission. You must be the owner of this debt. In addition, since I have never entered into an agreement with you, you must have a legal right of ownership to collect this debt. The purchase agreement will establish this. And in the last big statement I put in there, this is an attempt to receive the purchase agreement. It just goes in all the stuff you're trying to receive. It also says, I will file a complaint with the following if this debt is not resolved. And it goes into some of the little things. All correspondence should be through mail, no phone calls, your name and address. Always put the last 4 of your social in there on both the letters, because if you don't, they're going to try to act dumb, like they don't know where this is coming from. So put the last 4 of your social on on the second page of both ones. That's what I do. The account number, the amount, and sign and date, and send it off certified mail. You send it off certified mail because now they're on the clock. When they receive it, you go in, you find out when they receive it, you write that date down and say you got 30 days to get it. Now you got proof if they're not following the Fair Debt Collection Practice Act on their time to respond. It says 30 days. You got 30 days. They send you a letter say we didn't have time enough. Nope, that's not what it doesn't say in the Fair Debt Collection Practice Act that you got 30 days, but if you send a letter saying you need more time, you got more time. No, it doesn't say that. It says you got 30 days. I'm giving you 30 days and I need to be this response back in 30 days. You got it on the 1st, the 31st, I don't have a letter. You got 30 days. That's what I want. I want it in 30 days. If it ain't 30 days, you violated the Fair Debt Collection Practice Act, and now I got a little bit more leverage on my side. So these are the letters that I put together. I appreciate you, hanging out, going through this with me. But if you have any more questions, you know the deal. Just shoot me an email. We'll talk about it. Please subscribe. Please like. Please share. You know the deal. I'm trying to get y'all this information as much as I can. Any questions or anything else, I'm more than happy to help you. I know I've been getting a lot of emails lately. I apologize if I don't get back to you. Like, again, I do have a full-time job, and I got other things going on, other areas that I'm still trying to improve on my wealth. I've been back into my stocks really blowing it up, really doing well. Last week was a good week. Now I definitely need to talk more about that on this channel because that's a part of growing your wealth. So I do talk about it when I talk to people who call me to get them. And, I got a lot of people say, hey man, let's go. I do have a Facebook group called Investing to a Million Stock Group on Facebook. You can always come out and join. I'm definitely going to be more active on that now. I was very active on it, come back, but I've been dibbling, dabbling on it, but I'm really going to be a lot active on it, but because you got to be able to get your credit right. You got to know what to do with your money to invest and grow your wealth. So, hey, I appreciate y'all. You got any questions, you know the deal. Shoot me an email. Please like, subscribe. Leave me a comment. I appreciate y'all. Hey, I thank you for, just coming out and hanging out with me. And I'll see y'all in a minute.